Well, it got quiet. Okay, so I was afraid I would be interrupting great conversations. Hi, folks. I'm Mike Sutton, class of '76, and I'm the interim director of athletics right now, and the director of advancement for athletics. And I hope you've been enjoying your lunch and your conversation so far. I had the opportunity to introduce a person who I crossed over with at CMC back in the day, Steve Strauss. So I don't refer to Steve as a guest speaker because he is coming home. He's returning to his alma mater. We crossed paths during my senior year after he transferred to CMC from Georgetown. Now, while I spent my time in the pool, he was spending his time out on the links as a stag golfer, and that's when he wasn't in the library. He always knew he would be an attorney, but who knew when we were in our 20s what the next 35 years would hold? Steve Strauss is a first chair trial lawyer in Cooley Global Litigation Department, and he's achieved trial verdicts and settlements in excess of $10 billion. He's one of the country's most sought-after trial lawyers for complex commercial litigation, including business, intellectual property, environmental, and real estate matters. Most recently, Steve's been recognized by the Daily Journal as one of 75 leading intellectual property litigators in California, the top 100 attorneys in California, and is consistently named one of the top 50 attorneys in San Diego for business litigation by the Southern California Super Lawyers. At Alumni Weekend last spring, Steve received the George C.S. Benson Distinguished Achievement Award, recognizing outstanding professional and public service, and this is the highest honor bestowed by CMC's Alumni Association. Steve's a current member of and has been honored by the American Board of Trial Advocates, the Associations of California Trial Lawyers, San Diego Trial Lawyers, the San Diego Bar, and American Business Trial Lawyers. But above all these accolades, Steve said he is especially pleased and grateful to be a fellow of the International Academy of Trial Lawyers. Now this group's mission is to promote the rule of law internationally. The IATL is a key philanthropic passion of Steve's, and he shared special pride in a couple of recent projects he has shepherded. The development of a medical clinic in Amazon backcountry with his partners there, and the developing of a women's dormitory at a school in a Moroccan Berber village, leading to an unprecedented uptick of young women entering the educational programs in a culture and environment not encouraging female participation. So you're not likely to hear about any of this from Steve unless you ask, but he came to share his experiences more recently with assisting the family of Junior Seau, Hall of Fame football player for the San Diego Chargers. Their decision to take on the Shield, to take on the NFL in the concussion litigation program will be his primary topic today. So will you please join me, Steve, welcome back. Will you please join me in welcoming Steve Strauss.
Good afternoon, everybody. Thank you for inviting me to speak on campus. A little bit's changed in 40 years since I graduated CMC. The biggest difference I see, which I'm glad to see, is what a diverse student body we've become. When I graduated in 1978, it was the first class to have any women. We had 2 women graduate with our class. I played on the golf team, I lived in Beckett Hall, and have great memories from CMC. From there, I went to UCLA Law School, became a lawyer. I've been practicing for more than 35 years. I'm a trial lawyer. I specialize in business litigation, which means what it says. I litigate business disputes, all kinds of business disputes, from very large clients like Qualcomm, where I've been a lead outside counsel for the last 15 years, to cases like the Seau case. I love what I do. I love being a trial lawyer, and much of my passion was instilled here at CMC, and that's what I hope for you. So let's talk about the Junior Seau case. So I met Junior in 1997, a little more than 20 years ago, and Junior was referred to me. He had been defrauded by his business manager and agent, a man named John Gillette, who represented Junior and a bunch of other athletes, and he had absconded with their money. And so, as I said, Junior was referred to me, and I was able to help him resolve his legal problems. We became friends. I helped negotiate his last contract with the San Diego Chargers, which at the time was the largest guaranteed contract ever for a football player at $18.5 million. And I became a member of his foundation, the Junior Seau Foundation, which was an amazing organization. It raised millions of dollars for underprivileged youth. I put Junior in the hands of a good money manager, an accountant. I got to know his young family, his wife, and he, as you know, went on to have a glorious career. Junior was an NFL hero. He played in the NFL for 20 years. He played more downs at linebacker than anyone in history. He played in 12 consecutive Pro Bowls, and he was unanimously and posthumously elected to the Hall of Fame in 2015. I had lost touch with Junior after this earlier time that I told you about, when I had helped him after the defrauding by his manager. And I had followed that he had gone on to Miami and then to New England. On May 2nd, 2012, Junior Seau tragically died. He committed suicide with a single gunshot to his heart. He left 4 children, ages 12 to 22, Tyler, Sydney, Jake, and Hunter. He was by far the most famous athlete ever to be associated with chronic traumatic encephalopathy, CTE. And his suicide made him the poster boy for the problems facing the NFL concerning neurological injury. The manner of Junior's death suggested that he knew he had CTE by shooting himself in the chest to preserve his brain for study. And after Junior's suicide, at the very young age of 43, the family was descended upon. Experts were showing up at the coroner. They wanted to get his brain to study it. Plaintiffs' lawyers descended on the family, trying to get them to sue the NFL. And the family called me, and they asked if I would help guide them through this process. And the first thing I said to them, because Junior's legacy was very important to them, is that we needed to make sure there was a proper basis to bring a suit against the NFL. We needed to study his brain. And so what we did is we entered into an agreement with the National Institute of Health, the NIH, and in a first of its kind study. It was independent and triple blind, meaning there were 3 brains that were studied by the 3 top experts in the field of neurological injury. 2 of the brains were of people who had no neurological injury. The 3rd brain was Junior's. And the experts unanimously identified Junior's brain, and they conclusively determined that he suffered from CTE. And that diagnosis did 2 things. First, it confirmed some of the erratic conduct that Junior had been experiencing in his last years. He had poor impulse control. It manifested itself in gambling and drinking. One incident reported to me by his son, by Jake. He took him to a soccer practice, left him there, went to a casino, started gambling and drinking, and forgot to pick up his son at practice, forgot that he even left him there. And that was not the Junior we had come to know over the years, the Junior that the world had come to know. In addition, he had horrible mood swings. He became distant from his family. And then there was another incident that some of you may remember about a year before his death in Oceanside. He drove off a cliff. And he survived that, and he told the police that he had just fallen asleep at the wheel. But in retrospect, it seems pretty clear it was a prior attempt to take his life. And so when Junior's diagnosis came back consistent with CTE, The family then came back to me and said, would you represent us in this case? And I went to my firm and I said this was something I'd really like to do, and the firm supported that. And I was very grateful for that. It's not a typical kind of case for Cooley, my firm, to take, a personal injury wrongful death case. And let me just say there for a minute, since I hadn't mentioned that I'm a partner with Cooley LLP, and we have about 1,000 lawyers. We have 10 U.S. offices and 4 foreign offices, and we primarily represent a lot of emerging companies, technology companies. We took more companies public last year than any other law firm in the country, and I practice in the business litigation group. So when the Seau family came first to me for counseling, I was comfortable doing that because I knew that they needed guidance. And when they came back to me and said, would your firm represent us? I was very gratified when the firm supported that. And it was a very different experience for me handling that case. And so the claims that we made against the NFL were claims for wrongful death and claims for Junior's injuries. And those are different. 2 sets of claims. Junior, the decedent, he had claims for the injuries that he suffered while in the NFL and afterwards. But his children, the heirs, had independent claims that arise under California statute for wrongful death. And those claims, again, they don't even arise until the death of Junior, and those claims are for their loss of comfort, care, and society, not having their father, and also they allow the family to recover the present value of his future earnings. And in Junior's case, that was enormous. I mean, think of Junior Seau and his charismatic personality at 43, and all of the earning potential that he had by way of endorsement or sportcasting or book writing. So his claim was really a game changer. Most of the other claims, and I'll get to that in a moment, were just for medical injury, but the Seau children had this unique claim for wrongful death, and that was unique in the litigation. Now, the NFL contested this litigation, as you all know. In fact, for years, the NFL had disputed the link between football and CTE, despite known and growing evidence to the contrary. There's evidence going back 50 years that the NFL knew when these players were taking hits and they were being told they got their bell rung, that in fact it was a concussive hit, and in fact it was a hit that would have long-term consequences. And that information is becoming more publicly known. But the league disputed it, and in fact, the league formed a committee back in the early 90s to deal with the concussion issue, and they appointed a rheumatologist, Elliot Perlman, to head that committee, not even a neurologist. So the NFL, for many, many years, denied the link, again, between CT and football, and in the litigation, they denied that even if you had CTE, that caused the injuries, other than some of the injuries like more advanced, like dementia, ALS, Alzheimer's. So when we decided to file the case on behalf of Junior's family and Junior as a decedent, we filed the case in state court in San Diego. And the case was immediately removed to the federal court, and then it was joined with the much larger ongoing class action, the concussion litigation. And as I think many of you know, maybe you saw the movie Concussion, there was a major class action litigation filed against the league. It was consolidated in the Eastern District of Pennsylvania, the federal court there, in front of Judge Brody, and it involved more than 5,000 former football players and their families. Most of them still alive and mainly seeking medical care because they badly needed it. And the NFL fought the case by claiming that player safety and player health was the subject of collective bargaining. So under the National Labor Relations Act, since it was a subject of bargaining, the league argued that the players didn't have the right to file a suit in court, that they had to take their claim to arbitration and file a grievance under the arbitration procedures under the bargaining agreement, even though those grievance procedures were completely silent on how you would grieve this type of an injury. Another reason the NFL did that was so that they could keep all of the facts that were discovered in the case confidential, because arbitrations are confidential. And so that became the primary battleground. The league moved to dismiss the claims, claiming again that the players could not bring them in court, and the players contested that. And the judge then did something that was, you can characterize it how you like, if it was smart or not, but the judge said, I'm going to take this motion under submission, and I'm going to order you to go to settlement. And so the judge ordered the parties to go to settlement. A mediator, Lane Phillips, one of the preeminent mediators in the country, was hired. And after about a year, he mediated a settlement that the NFL offered to the players, which primarily provided for ongoing medical care. It provided some benefits to the sickest players. But it made no provision at all for the heirs. And so it made no provision at all for the Seau family claims, which were unique. And as I mentioned before, those claims arise separately under California statute, and those claims were not the subject of bargaining and could not be bargained away. So the league didn't have the same argument to dismiss the claims of the Seau children that it made against the players. The children of Junior were not signatories to any collective bargaining agreement, and as I said, their claims didn't even arise until he died. And so that then became the league's worst nightmare. Junior Seau became the face of the concussion litigation. This became the one case that the NFL feared above any other case. And recently the case was successfully settled. I can't talk about the settlement terms with you, but I think the difference maker was two things. One was, as I just mentioned to you, that the Seau family had unique claims that the league wasn't going to be able to just dismiss, and the case had tremendous value based on Junior's celebrity and Junior's future earnings. And the other was that Cooley was a formidable adversary. Most of these plaintiff players were represented by small lawyers, small law firms, or individuals, and the NFL is very formidable. They took a scorched earth approach. No surprise here, they're bullies. And they were able to intimidate, I think, a lot of the players, and they were able to forge a settlement that was very favorable to the NFL, even though the impact of it has been quantified at maybe $1 billion over time. When you think about the extent and severity of the neurological injuries these players encounter and are going to continue to encounter, I think it was a favorable settlement for the NFL. But that didn't work as to the Seau family, and the NFL knew that with respect to Cooley and with respect to me representing the Seaus, that we would go all the way. And that leveled the playing field, and I think that helped to influence a favorable settlement. The media took great interest in Junior and Junior's death and Junior's link to CTE. And I think that that has shone a light on CTE in society today. And you may have seen some of the programs. There was an interview on Outside the Lines that ESPN did of the family a couple of years ago. There was a feature presentation on 60 Minutes Sports. There was a 30 for 30 ESPN documentary just a few months ago on Junior's life and career in CTE. And the New York Times followed the case from start to finish, including another event you may remember. When Junior was elected to the Hall of Fame in 2015, his daughter Sydney wanted to give his introduction speech. And the NFL refused to permit that because they were worried that she would use that as a platform to speak against the NFL and speak out against CTE, which of course she was not planning to do. She was planning only to honor her father. So the New York Times published her speech the next day on the front page in response to that. So the case generated a lot of publicity, but I think important and positive publicity as to the problems that these players are facing. And it's a very real societal problem. You know, when we talk about CTE today and in the future, you have these football players whose average career span is less than 3 years. They come out of school, not educated, because the education is really just a vehicle to have them play football. And then they're 27, 28 years old, and they're brain damaged, and they're now in society. And it poses tremendous societal issues and risks. And the NFL, in my personal view, has not done enough to be there for these players. They've made tremendous profits on these players. They've glorified on film and in NFL games violence. And now you have all these players out there in society, and they need help. And the medical monitoring that they're providing is a very baseline. The resolution of Junior's lawsuit and the resolution of the class action haven't changed that. CTE remains a very real problem. You've, again, probably seen some of the data, but in all the studies that they do, 99% of these pro football players, when they study the brains posthumously, have CTE. And part of the problem with treating CTE is that you can only test for it posthumously, meaning after the person's died and you take out the brain and you study it. And then if you look at these slides, it's visceral. I mean, you see the tangles, you see the colors, under the microscope and on the frontal lobe. And it's no surprise to you that it might impair their cognitive function. But there's no test to be able to determine the existence of CTE while you're alive. And so that's the most important thing, and that's where a lot of the energy in the field is being directed. UCLA now has some MRI testing that they're developing. Others are working on it. I think in the next couple of years, you will have an in vivo test to be able to determine if there's CTE. And that will be huge, because Ann McKee, who's probably the preeminent expert at Boston University, postulates that there's 4 stages of CTE. Stage 4 would be the punch-drunk boxer. Stage 1 would be the beginning stage. But we don't know if those stages are treatable, if those stages are reversible. And so by being able to identify it earlier, hopefully that will lead to the ability to treat it. But even in this day and age of CTE and the NFL finally acknowledging it, in fact, only in the last year have they acknowledged that there's a link between CTE and football, although they won't acknowledge yet a link between CTE and neurocognitive disease. They still express skepticism, and they still have heightened sensitivity to even discussion of CTE. You may have seen the other day that Bob Costas was taken off of the Super Bowl reporting team because he broadcast, in one of his broadcasts, he made comments negative to the NFL and criticizing the NFL for its lack of attention to concussions. And so their response to that was to yank him from the Super Bowl team. So what I'd like to do before opening to questions in finishing is I'm going to show you some excerpts from a video that we had prepared in the case that we used at the mediation of the Seau versus NFL case. So with that, I'll show the video, and then we could take some questions.
Junior Seau, the monster in the middle, a defensive icon who for 20 years dominated the NFL with his devastating hits, more than 1,850 tackles, and 12 consecutive Pro Bowls. Off the field, Junior was a devoted and loving father of 4. His first son, Tyler, was born in 1989 to Junior's high school sweetheart, Melissa Waldrop. In 1992, he married Gina DeBoer and had their first of 3 children, Sydney in 1993, Jake in 1995, and Hunter in 2000. He was also committed to serving the community with the Junior Seau Foundation, which donated more than $4 million to San Diegan children and young adults.
911 emergency.
But Junior shocked the nation on May 2, 2012, with his sudden and shocking suicide. By shooting himself in the chest, he chose a clear method to save his brain for post-mortem examination. Findings showed Junior's brain had explicit signs of CTE, chronic traumatic encephalopathy, the progressive and degenerative disease found in 99% of deceased NFL players. For years, Junior Seau, Junior's former wife, to whom he remained close, and his 4 children struggled to understand why the person they knew as loving and kind changed so drastically in his final few years, ultimately becoming detached and alone. Classic symptoms of CTE. During Junior's NFL career, the NFL had not yet disclosed the already known relationship of repetitive blows to the head and permanent brain damage. And instead of warning players, the NFL monetized the violence of the game and encouraged players like Junior to continue playing.
Run, hit, run and hit. Run, hit, run and hit. Run and hit!
I lost a dad. I know other people lost their linebacker, their favorite all-time Pro Football Hall of Famer. All of that didn't mean anything to me. I just wanted someone to walk me down the aisle someday.
I don't think he knew how to deal with what he was going through. And to be able to stand in front of you and smile, I think it got harder and harder and harder for him. Had I known what he was going through and the symptoms and even the possibilities of what he could be dealing with, I could have talked to him.
There were multiple red flags, but the people closest to him were not informed on how to connect the dots. As a result, Junior's children are left with feelings of guilt and regret for not coming to their father's aid and saving his life.
And I think it would have been easier for all of us to understand that. It wasn't our dad that was doing this on purpose. We would have known how to handle him in a way that wouldn't have ruined relationships. There would have been an understanding, sympathizing and empathizing with him more than what was given, because we all loved him and we wanted him to be there.
Whenever I was with him, he always made me feel like I was the best son in the world. And we'd have so much fun, but we didn't have enough time.
I get emotional every time I see that video. And with that, I would be happy to take some questions.
Thank you, Steve. I have a microphone. Caitlin has a microphone. Raise your hand and we will bring it to you if you have a question.
Hi, thank you for coming to speak today. I was wondering, I don't know how it works with insurance, health insurance for NFL players, but is it possible for the insurance companies to also go after the NFL, kind of like in a similar situation how PG&E just declared bankruptcy and the insurance for the wildfires are trying to go after them for the increased cost, if a similar thing could be done with the NFL?
Yeah, good question. So there's currently a lawsuit between the NFL and its insurance carriers. The NFL is seeking insurance and the insurance carriers are claiming that they don't insure for this risk. But what's interesting is that may be the forum where all of the factual evidence comes out, right? One of the things that happened in the case, in the class action, is that once the league filed the motion to dismiss, it stayed or stopped any discovery. So no documents were produced, no depositions were taken. And then the case got settled, the class got settled before discovery commenced. But in the litigation, so ironically, perhaps, the league is very interested in not having that information, I think, come public, what they knew when they knew it. But the insurance companies are subpoenaing and requesting all that information from the league in their litigation, and so that may be the place where it comes out. Also, your point about insurance has another ramification that I didn't mention, and it's that you're seeing the elimination of youth football, Pee Wee football, Pop Warner, even high school. And that's because the costs of insurance are so high the schools can't afford it. And so if it's uninsurable, then they can't operate the program. So I think that's another thing that you're seeing in the future is much less participation at the youth level because of the inability to be able to get insurance.
Hello, thank you for coming to talk to us. I was wondering how the calculations for the present value of his future earnings are carried out, specifically if the NFL or whoever is in charge of this would assume or carries them out, assuming that Junior would have not contracted CTE from the very beginning, or whether they are carried out in terms of how his life would have turned out even after having CTE had he lived to his full lifetime.
It's a good question from someone who obviously has math background. So the way that you calculate the present value of future damages is you take his age at death, he was 43, and then you go to the actuarial tables and you see if he wasn't diseased, how long would he have been expected to live, and then you take that time period and you look at what his potential earnings could have been over that time period, and then you discount it to a present value. And so we hired two very renowned experts. I won't name them, but I hired an agent who represented a lot of first-round draft picks and very prominent athletes to learn from them the types of opportunities Junior would have had. And I mentioned it would have been endorsements for various products. Sportcasting, certainly, he had had some sportcasting experience. And you then take those things and you get data, and we had hired an economist from Stanford to do that, and we gathered data of what football players were earning who were similarly situated to Junior. So you take one of the greatest linebackers in the game and you look at other players who were highly successful, who had 10 plus Pro Bowls, played as many seasons, Hall of Fame. We came up with a subset of comparable athletes and used that subset of comparable athletes to then develop the data as to what they were making from these various opportunities, projected that over Junior's, again, lifetime, and brought it back to a present value. And again, I can't share the number, but I can tell you it was considerable. Yes.
Hi. My question is, in all of the research that was done in his brain, is it a possibility that this was a pre-existing condition for him prior to going into the NFL?
So that's a good question too, and one certainly, and that question forms one of the main defenses that the NFL has, which is prove that your concussive hit was in the NFL. Maybe you had it in college, maybe you had a concussion in high school, maybe you had it in Pee Wee football. In Junior's case, he played Pop Warner, he played high school football, he was a star, he went to USC, he was a star. Undoubtedly, he took some hits, probably concussive hits earlier, but there's also no question that he had numerous concussive hits in the NFL. And so, you know, one of the legal issues that was very important that we had to factor in as to whether to settle or not goes to your question. Would we be able legally to meet the hurdle to get to a jury the question of whether the concussive hits that he suffered in the NFL were a substantial factor, that's the test, substantial factor in the injuries he suffered? You know, we believe the answer to that would have been yes, because even you saw, you know, on that little bit of footage, there were documented instances of concussive injury. But no doubt, in answer to your question, he and other players suffered concussive hits at other times. And that's why the research is showing that particularly before the age of 12, you're much more susceptible to CTE and long-term consequences. And that, I think, is a huge factor in, as I said, what I think will be the elimination of tackle football at the youth level.
With your knowledge of both CTE and the NFL and kind of the relationship they have with one another, once they or if they are able to diagnose it among living ex-players or current players, do you see the NFL surviving that, or are you just going to see more financial security for the players?
Yeah, so that's also a very pertinent question. What's the history of football? Undoubtedly, the study is going to show that CTE is caused by concussive hits. That's not disputed. And as the science gets better, it's going to show that you can associate it with these conducts. So I think that's a given. Will that lead to the elimination of football? You know, you tell me, probably not. It's America's favorite sport. It's highly profitable. Today, what the league is doing, if you want to play football, pro football, is you have to do a waiver on video. But there's a question, you know, if it turns out that that's some kind of an intentional tort or intentional wrong, is that an enforceable waiver? We don't know yet. Is that waiver work against, you know, the future generations? Would that be applicable to the Seau children whose claim didn't even arise till their father died? So I don't think that gets the NFL out of it. I think you will see more self-selection out of football in places where children have more opportunities and their parents perhaps have better demographics. They'll play lacrosse, they'll play soccer, they may not play football. In other places where football's religion, the South, Texas, I think they'll probably still play football. So you know, what I suspect you'll see over time is more limited participation, but it's hard to see football going away. If I was a football team owner, it'd be a good time to sell. But and I guess a follow-on to that is that always gets asked is, can you make it safe? And so there's been rule changes, there's helmet changes. I think the NFL is paying a lot more attention to it. They're studying it, but I don't know if you can make it state. It's inherently a dangerous sport. And these athletes are big and fast and strong, so I don't know that you can make it safe.
My question is regarding the collective bargaining agreement. So with this like newfound litigation, how will it affect the like upcoming collective bargaining agreement in relation to concussion protocols? For example, you have like 2 years ago, Le'Veon Bell get a concussion week 17, playing in the first round of the playoffs, only a week later. So there's players that have a desire to be back to produce for their team, but that can then lead to them getting CTE and not having that going through the proper stages of a concussion protocol.
Yeah. So I think you're right. You can't leave it to the players to make their own decisions because they want to get back in there. So the league has to be the adult, and I'm glad to see these protocols. You know, I think they help. And I think the next bargaining agreement will address this even more. It still hasn't been answered by the court whether the league can bypass the courts by claiming it's a subject of bargaining and force the players to grieve in arbitration. I think that they should be able to bring litigation and not be forced into arbitration because the arbitration process isn't set up for that. And just to say that the collective bargaining agreement covers medical care, I think is too broad of a brush. It doesn't cover the league's conduct, certainly in concealing information that they knew or making misrepresentations. And that again will be different for the player of today and tomorrow because much more information's in the public. But when Junior played, they didn't know. He used to joke with his wife Gina that, you know, you're going to be pushing me around in a wheelchair someday. Players understood they were at musculoskeletal risk, but they didn't know that their mental health was at issue. So I think it's a different claim for players who played 20 years ago, 10 years ago, than players playing today. And I also don't think it can be completely addressed in bargaining, but they've got to try and make it as safe as they can.
We have time for one final question.
So it's kind of regarding the like whether or not you can evaluate like the NFL as as causing CTE basically. I was kind of wondering, so if there are people that retire from football after college, has that been studied, the prevalence of CTE in those kind of people? Because you said it's as like NFL players, it's 99%, but if it was a number like, 40% for college athletes, then you kind of tell like the discrepancy between those two. So has that been kind of studied to any extent?
So again, the problem is that you have to wait till the person dies and study the brain, and there hasn't been as extensive a study, to my knowledge, of college players who didn't play pro, as there has been of NFL players. The study on NFL players showed that the brain's examined about 99%. Undoubtedly, there will be a high incident. I don't know how high. That's why you need a diagnostic test while they're alive to tell. But there is, the NC2A has also been sued by former college players, and member schools have been sued. I don't know if CMC has any claims, hopefully not. I know that many of the schools have. And so there are players who played only college, not pro, who have CTE. And in fact, there's a recent suicide of a football player in Hawaii who has sued USC. So you have similar instances, but we don't have the brain data yet from as many college-only players.
Let's thank Steve for returning to CMC. Thank you, everyone.